Hello, everyone, and welcome to the 2021 edition of the Trinidad and Tobago Film Festival. I'm Tanil Niwalo, Education Coordinator for ttff 21. This year, we have an abundance of films and industry events that consist of masterclasses, workshops, presentations, panels, talks, info sessions, and a new discussion series entitled Ask the Veterans. We also have Q&As and alignment live with filmmakers, so please be sure to check out our website or social media pages to find all the events or films that you might be interested in. We have one day left after today. So today I'd like to welcome you to the live presentation of Understanding Copyright, brought to you with the support of Republic Bank Limited. Filmmaking is a complex, collaborative undertaking. It involves many different layers of rights that relate to different elements of production, all of which need to be licensed, documented, and transferred for a producer to claim ownership of a film. Having creative rights to literary or artistic work is necessary if you aim to prevent others from using your work without permission. So in this 1-hour presentation, lawyer Cindy F. Daniel will answer important questions about why copyright is important to filmmakers, how copyright permissions impact budget, and how filmmakers can protect and enforce copyright. She will also provide case studies on copyright conflicts in film and television. So a little bit about Cindy F. Daniel. She's an attorney with more than a decade of experience in both the legal and creative fields. After being called to the bar, she worked primarily in the public service, having been attached to the ministry with responsibility for culture for the last 6 years, where she collaborated with the Intellectual Property Office to facilitate capacity building workshops for artists and provided support to grant recipient filmmakers. She has significant experience in policy development, contract negotiation and drafting, as well as intellectual property. Daniel has a postgraduate certificate in entertainment law and industry from the prestigious University of Southern California, and is currently one of their 2022 LLM candidates. So I will now hand you over to our facilitator, lawyer, Ms. Cindy F. Daniel.
Thank you so very much, Tanil, and it's great to be here with Film Festival again this year. We have a lot to cover, so I'm going to just try to dive right into it. Copyright is a very complex and sort of esoteric subject, so we only have 1 hour. We're going to try to keep it high level, really give you the basics and a lot of the fundamentals. So by the end of the presentation, I think the point is for everyone to be able to have a grasp of copyright, to understand it and how it's important for filmmakers, the things that you need to pay attention to, the things that you need to make sure you have covered so that you can minimize your risk in terms of your legal risk, risk of litigation. All right, so I always have to begin with a disclaimer. So this is just a dotting our I's and crossing our T's. Okay, so just so that we are all on the same page, this does not constitute legal advice. This is a presentation that's for information purposes only. Okay. The question, of course, we first get is, what is copyright? All right. Now, I want you to pay attention to the fact that I put in the word original there. Copyright, also known as the author's right, is a legal term used to describe the rights that creators have over their original literary and artistic works. Okay, now this is a definition that was given by the World Intellectual Property Law. And I stuck in the word original because we need to know that copyright attaches to creations of the mind when they are expressed in some sort of tangible medium. Tangible as in computer, that includes computer when you type something onto the computer, because then you can save it. You can represent it, as opposed to if I were to break out into a random interpretive dance and we were not being recorded. By the time I was done with the dance, then it's just disappeared. Whoever was there saw it and it's gone. It was ethereal. So that's the difference. From the time you start recording, then copyright can attract, because it's being fixed in some sort of medium to be reproduced. That is essential, because the entire point of copyright is that it is to be an economic right. It's supposed to be able to give you the benefits, some sort of financial benefit for your intellectual creations. Original, I stuck in because it's important. It means that not everything you do will attract copyright. Okay, there's a threshold for originality. Now, the threshold is very low, so don't mistake originality for artistic quality. Okay, that means a child can do a finger painting and that will attract copyright. Doesn't mean it's a Mona Lisa, okay, if an 8-year-old does that. But because there's a certain degree of originality attached to it, it's copyrighted. Whereas a stick figure might not. So you see the difference. Now, if your stick figure were to have a few extra additions, then maybe it will cross that threshold of originality. And why would your stick figure not attract copyright? Because remember, it's a monopolistic right. And that means the person who has copyright is entitled to do things. You can tell people that they can't copy it. So if I drew a stick figure and then suddenly that was copyrighted, that means nobody else would be able to draw a stick figure without getting my permission or paying me money. And that doesn't sound right, does it? And that's where the originality element comes in, so that we can distinguish those things that should be protected or are capable of being protected versus those things that can't be protected. So remember, the threshold is very low, but it still exists. Okay, and that's important because in disputes, as you will see, very often what is disputed will contain both elements that are capable of attracting protection, and it will also contain pieces that don't attract protection. Okay, now copyright is of course related to artistic works. So it's copyright is the type of intellectual property that relates to things like films, sculptures, music, computer programs, ads, technical drawings. There are other types of intellectual property, okay, that make up the entire group of IP. Intellectual property abbreviation is IP. Copyright is just one. Copyright attracts and protects those items. But there are other types of intellectual property that we will not cover here. Trademarks are an example, and trademarks are also very popular and very relevant to the film industry. But there is a distinction between the two. They are two different and distinct forms of intellectual property. Trademarks are related to things like slogans. It's possible even, and we will see, to protect a title of a film as a trademark, but it's not capable of attracting copyright. So the most important thing out of everything I said was the original and fixed. Copyright does not protect ideas. Now, this is a question we get all the time when people say, oh my gosh, this person stole my idea. Well, they can't steal your idea because it doesn't have copyright attached to it. Why? Because we just explained the whole thing about a concept being ethereal. So if I just imagine up this great concept and I just talk about it off the top of my head spontaneously, and somebody was close by and they heard it and they decide to run with it, and then they go and they write it down and put it into a screenplay, I may have lost the opportunity to capitalize on that because I didn't put it into some sort of tangible form first. We will get more into idea theft, okay? I want you to remember that copyright does not protect ideas, but there might be other ways that you can get protection from an instance like that, because it sounds unfair, right? Just remember, copyright is probably not what's going to be able to protect you there, but maybe you'll be able to get some other form of protection. So we move on. You will want to know when you get copyright, all right? So we talked about the original creations and where does it come from and when do I get it? At the global level, countries come together and they decide what kinds of copyright protection should be available for creatives, okay? And then they decide on a certain minimum threshold of rights that would be beneficial to authors. So when they do that, that's how you come up with your conventions, and then all of the countries who agree and say this is a good idea, I agree with this, all of the countries come and they sign on to the convention. So at the global level, you have conventions related to copyright that give the minimum thresholds of protection. And just so that you know, the general minimum protection is period of protection that somebody can have copyright for is the term of their life plus after they die, 50 years after they die. So however long you live plus 50 years post-mortem. Okay, that's like your minimum. And then each country has to agree, once you've signed on to that convention, to that minimum. You are still entitled as an individual country to give more, but you can't give less. And that's how your individual copyright laws in each country comes about. So by that token, Trinidad and Tobago will have our own Copyright Act, which we do, and we've had for a long time. And we do subscribe to the Life Plus 50. But in Jamaica, it's Life Plus 95. And in the US, it is even more for companies. That's mainly attributable to Disney, believe it or not, because the Mickey Mouse character is one that was created many years ago. And if it had just been for the life of Walt Disney and 50 years, then you could imagine that it would, after copyright expires, anybody can use something. So similarly, in Jamaica, they decided, again, because of Bob Marley, he died, in the 80s. And if you think about it, somebody who was born in the 80s is 30-something years now. And if you only had life plus 50, that means you'd only have maybe 15 more years of protection, and then everybody can use any Bob Marley song any way they wanted. Of course, they didn't want that. And protection in Jamaica, especially because music is, I personally think, especially because music is so important to them, it's actually life plus 95. Right? But here in Trinidad, it's life plus 50. The rules for how long copyright might last also changes depending on whether you're a human or a company. As I mentioned, Disney is a company. So the laws will dictate whether the term is going to be the same for a company or whether it's going to be more for a company or less. Okay? Now, also, within your local legislation, as every country, after they've signed on to the convention, they then get to go back home and do their own law and kind of tweak it how they want it to work there. Based on every individual country's laws, copyright laws, you will have nuances and different requirements. Okay? Now, in the US, they require registration at the US Copyright Office for artistic works. And we discussed the kinds of works that can attract copyright. We said sculptures, screenplays, plays, films, paintings, visual art, technical drawings, computer programs, all of those things would be registered by whoever created it at the US Copyright Office, because their laws say that they require registration, not for protection, because remember, they signed on to the convention, and we'll get into that. The copyright protection actually occurs at the moment you create it. So it's not for protection, but it's just because their law says you have to do it in order to sue somebody. All right? So it's not about, so each country, because they can choose how they want their copyright law to work at home, it doesn't relate to the protections, which everybody at the world level decided on minimums. But at home, they decide on how it's going to actually work, the practical side of it. And this is where you usually have to, and this is why you need to be advised about copyright in individual territories when it comes to lawsuits. But at the global level, you can take comfort in knowing that everybody who has signed on to a convention will have the same minimum protections, and they recognize it in other countries. So if you're protected by copyright in your country, you are protected by copyright in the 190 something other countries that have signed on to the Berne Convention. The Berne Convention is the oldest convention and the one that almost every territory has signed on to. So I think you want to know what rights copyright will give you. Okay, you hear the word, I have copyright in this, and we'll go to the next slide. But what exactly does that mean? So you've created something, you've written your screenplay, and you want to know what exactly, I know I put it on my computer, so that means it's now fixed. What rights do I get from copyright? Copyright is actually a bundle of rights. It's not just one. And that's often the first misconception people have, that they assume it's just one right. It's actually a bundle of rights, and they are exclusive rights. That's important to remember. What is an exclusive right? It means that you can exclude people from doing things. So that's pretty much the major difference between copyright and other kinds of rights. Copyright is an exclusive right. That means whoever owns it can prevent other people from doing things. As opposed to when you frame it in the opposite, when you have a right, you can do something. The purpose of it is to help you make money. So the best way is to prevent other people from doing things. And that's why it's called an exclusive right. So you've put all this work into writing this amazing screenplay or painting this beautiful picture. And now you want to know, which rights do I have from copyright? So think about it just like a house, because a house is real property. And copyright is the name of the bundle of rights that you get from intellectual property. If you have a real house, it's worth something, value, it's of value. And you can sell your house, which would be the same as selling intellectual property. When it's sold entirely, it's called an assignment. You can have your house and think, well, I don't want to sell it. I don't mind renting it out, and then maybe after a year, if I don't like this tenant, I'll get another one. And that you can do the exact same thing with your intellectual property. When you rent it out and get money back, that's called licensing. And that's rent is called your royalties, right? But think about intellectual property. It's even better because you can actually rent or license your intellectual property to more than one person at the same time, unlike a house, so that you can actually maximize. There's like almost no end to how much you can get in terms of a return on your intellectual property, unless you agree to have only one tenant or one licensee, which will be an exclusive licensee. So remember that the license is like renting. And all of those things can be negotiated. If you, of course, want to rent it to only one person, then you have to tell that person, oh, well, I could rent it to 10 different people and make more money. So if you want to be the only person, you have to pay more. And that's how the negotiation, the money-making aspect of intellectual property comes about, okay? So here within the slide, you'll see the rights that you have, okay? You have the right to prevent other people from copying your work and making reproductions. This is especially important for filmmakers because it goes directly to the heart of piracy. We've always heard the word piracy. We pair it a lot with music, but it's the same thing with film. Copying your work, if you didn't give permission, and selling your work, you don't get the benefit of the rent. and that's piracy. Copyright gives you the right to exclude people and prevent them from copying and making reproductions. It also prevents people from making adaptations. Adaptations is a tricky one because people usually hear adaptation and they think it's about changing the language of something, which is true. That's one form of adaptation. But adaptation also means changing from one medium to another. So, for example, actually moving a written screenplay to a film, taking it to your shooting script, which is written, and then putting it into audio-visual medium where you actually have now something, a visual representation of that is an adaptation. So again, the person who wrote it as the copyright owner has the ability to prevent other people from adapting it and putting it into a film version. You also have the right to prevent public performance, public display, and this means that as a filmmaker, you can prevent people from actually showing your film, if it were music, from playing your song or singing your song. And they always have to get permission from you if they want to do these things, because that's how you will be able to recoup from your cost. And also derivative works. This one is important, especially for filmmakers and musicians. Derivative works would be, from the perspective of a filmmaker, if you were to do a sequel, that's a derivative work. If your first film is so successful and you did a sequel that would be based on the original, then you have the right, the copyright owner is the person who has the right to prevent other people from doing these things. So those are the main rights you need to think about. Those are your economic rights. That's how you make money. The good thing about copyright is that it actually gives you not just economic rights, but also moral rights. The moral rights, as the name suggests, relate to paternity, artistic integrity, and how the work is treated. It has nothing to do with money, and there's no way you can make money from moral rights. They are personal to the author. They can't be sold as opposed to or rented as opposed to the economic rights. Okay, it really is about, as an artist, how you want the work to be used or not used, and those rights can't be transferred to anybody else. You can waive them. Okay, you can waive them in writing, and even that is debatable in some territories, but it's personal to the author. I'll give you an example. If you are the copyright owner of a black and white film, and this is an actual case, and you did it in black and white because you believed that it would be more impactful that way, it was a stylistic choice, and it has to be done that way for you to really get the message of the film across. And somebody wants to colorize your film, and as the artist, you say, well, no, that would be an absolute degradation of the work. It is not meant to be consumed in that way. You would have to rely on moral rights in a situation like that because it deals with artistic integrity of the work. Okay, it's not economic, but you would have the moral right to say, as the author, that my work that will be degraded if you treat it in this way. In the US, it's important to note that moral rights is very, very limited in its scope. So as remember, I spoke about the conventions where all the countries come together. So all the countries came together and agreed that moral rights are important. We need to recognize them. And of course, the US agreed to the concept. As remember, they can then go back home and decide how they're going to apply it at home. So they agreed with everybody, but they didn't really like it. So they said, okay, fine, we agreed with everybody, so we have to put it in our domestic law at home. So we're going to put it in, but we're going to make it really the category of work that moral rights apply to. We're going to make it really small, which is what they did. Moral rights don't apply to most things in the US. They apply to things like sculptures in particular, visual art. And even then, not all visual arts. This is like a category and then a smaller category. So that's just something that's important to note. It's very, very important, however, in the European Union. And of course, moral rights do apply here in Trinidad and Tobago, where we even had a recent case. Sean Carruth brought a case against the Tobago House of Assembly for a song. We all know the song Cool Pot. And they used it to advertise the Blue Food Festival, allegedly without his permission. And he said that he does not consume pork. And that was one of the main things that they were touting. And it was against his moral rights for them to use his song as the theme to advertise this festival. As an aside, he lost that case for another reason. He would have succeeded on the moral rights ground had he not agreed a subsequent year to perform at the festival. So he kind of shot himself in the leg there. However, had that not happened, I do think he would have succeeded. So now that you understand the bundle of rights that copyright gives you, and these are your economic rights, and you understand your moral rights, which are not economic, it's really just all about integrity of the work, no money involved, can't be transferred, it's just for whoever the author is. As a filmmaker, I believe you'd want to know why it's important to you. So it's important for you to be able to assert your copyright as the owner. What's the point of having this right if you can't actually use it? Okay, and we will discuss what asserting your copyright means. It's important because this is the way that you are able to financially exploit and make money from your intellectual property, by using the concept of copyright. This is how you establish chain of title, which is very important from the perspective of exploiting your work, and maybe you're hoping to go to get distribution, maybe a big production company or studio will be interested in doing the film over. All of these things they will need to know, but they won't do it if they don't know who owns it, because they need to know who do we need to get permission from. And it's also important for taking action against infringement. Okay, again, remember exclusive rights, so you prevent people from doing things. And if somebody is doing something that you know you didn't give permission for, asserting your copyright is how you're going to take action against infringement. So next we will consider film from the perspective of ownership. Okay, so you're saying to yourself, okay, so I know now that copyright is about making money from my intellectual property. But as Tennille said in our opening, it's a collaborative process. Unless you are a magician or you're very, very good and maybe you filmed yourself as every single character, art house film with yourself as every single character, and you use your phone to record yourself, where there's no dispute about who owns anything. But the vast majority of productions will not be like that. They will involve many moving parts, sometimes multiple writers. Maybe you'll have script edits along the way before you get to the final version. And the question comes up, especially because of creative work involving teams. Well, who owns the copyright if we all kind of worked on it? Which one of us owns it? And for the purposes of the law, right, the person who owns the copyright is called the author. And I know it's because, originally it was focused on books, right? So, but it transfers to film. It's the same thing. So the author is deemed to be the person who makes the arrangements for the film to be made. Okay? That could be your independent filmmaker, your producer, or your executive producer, which is, could be a studio. So most times, that's very clear. Who is the person who made all of the arrangements for this to happen? That person most likely is your producer or your filmmaker or your studio. That entity is your copyright owner. It can be a human, a natural person, or it can be a company, as we described when we spoke about Disney or Sony as a studio or Universal. Maybe you have your own production company, which is great, in which case your production company would be the one that owns the copyright. This is tricky where you're a filmmaker who has a business name, where you trade as a business name. If you trade as a business name, as opposed to a company that requires two directors, if you have a registered business name, then it's you. A business name is just a shield for you to use a different name versus what you have on your birth certificate. You as the individual will own it. If you have a company, your production company is the one that will own it. But even this is important to remember. You will have a production company and you'll be the only person working in it. Assume it's you and a parent or your spouse, the two directors. You need to make sure that there's some sort of paperwork in between there, even though it's your production company, that says the person who wrote this, who is you, that you assigned all of your copyright to your production company, which is your company. But in terms of that whole chain of title and establishing who owns it, there will be absolutely no doubt. Okay? So that's important for people who have their own production companies. If it has the word limited at the end of it, that's a production company. That you just make sure you have a one page saying that you, the screenwriter, assigned your copyright to the film you wrote or the screenplay, all rights in perpetuity, which means forever, to your production company that you own. Who owns the copyrights as the author or the copyright owner? Others need your permission. So knowing who owns the copyright is essential, because then when people start asking for permission, they need to know the right person to ask, because many a case has come up where people have asked for permission. They asked for permission from the wrong person and they got the permission, but they got permission from the wrong person. Or they got permission from one of two of the right people. Okay. It is possible to have joint ownership. And as we said, copyright is very collaborative. So we'll get into some of the conflicts that can happen there, because assume you and your best friend wrote the script together. You're going to ask which of the two of you own the copyright. Well, if you wrote it together, truly wrote it together, and it wasn't that one person wrote it and the other person made a few tweaks or made a few suggestions, then the both of you might own it jointly. Without something written, all of these things become very doubtful and questionable and can lead to disputes and litigation. So it's good to always have a conversation at the outset. So on that note, we'll get straight into some of those disagreements. We spoke about you and your friend writing a script together. The key to distinguishing whether you own it together or whether you own it or whether your friend owns it and you just gave some really great tips has to do with what you agreed to at the outset. What was discussed? Because if you don't have a written agreement and there's a dispute, it's going to come down to the evidence. What was discussed? Were there any emails sent back and forth? What were the conversations that you all had? Did you both agree and there was an understanding between you that this would be done together, to be owned together? And when that doesn't happen, you head into court. So using this, which is one of the more popular cases on the topic, this case of Al Muhammad and Lee, which is the Malcolm X case. So we all know Spike Lee, great filmmaker, who has his own production company, 40 Mules, 40 Acres and a Mule, right? And he decided he was going to be doing the film Malcolm X. A studio brought him in, his company, to do this film. And he was able to get this gentleman, Mr. Al Muhammad, to give him some really good tips about making the representation look authentic. So remember, there was Islam represented in the film. So they wanted to make sure he brought in somebody who knew about Islam, who was actually Muslim, and could tell them, well, no, that doesn't look real. You know, this is how you pray. The person also spoke Arabic because they shot on location in Egypt, I think, at some point, and he was their go-between as the translator, and he made a few little suggestions about changing these things in the script. He said, well, you know, Muslim people will greet each other this way, whatever it is. And at the end of that process, because there was no written agreement, he believed that he was a joint author of the film Malcolm X, and that he was entitled to all the money that the movie made, some of the money as a joint author. Of course, that was not what they ever thought or considered or agreed to, but nobody knows what was agreed to because there was no written agreement. However, based on the evidence and the role that he played, and the court rightly concluded this, there was no intention from the get-go to make him a joint author. He was just supposed to come in there and give his expertise and get paid. All right. Now, locally, there's the film Trafficked. Now, this one, there has never been litigated in court, so there's no outcome. I do think it should have been litigated so that there would have been a clear outcome, but it played itself out in the court of public opinion, okay? And it's an instance where a director of the film worked on the screenplay based on real life stories that came out from members of the production team and Ion Dependency, who was the producer. And somewhere between there, the discussion of ownership and the discussion of roles and responsibilities didn't take place very clearly. The film was entered into various film festivals and it attracted a lot of stamps, got a lot of acclaim. But remember, we spoke about copyright being an exclusive right. So if you prevent people from doing things, so if you believe you're the copyright owner and you see a film being submitted into different festivals and you are not the one who gave permission, you're going to have problems about that. It is on YouTube. I think it was never litigated. As I said, this is a situation where the director believed that he made significant contributions to the screenplay, and the producer had a different perspective. And it is one of those things that I think at this point it's not going to be litigated, but it descended, as I said, very dramatically played out in the public domain, and could have been prevented if there was a written agreement, even one page. So then everybody knows that they're all on the same page. So you have to ask yourself, am I an author? Is there a written contract? Please have written agreements. Even if you have to have an email, reduce it into writing so that there's no confusion when you bring people onto your project about what their role is. Also, it's important to note that, remember we spoke about intellectual property being like a house. If you want to sell your intellectual property house or your film, it has to be done in writing. And that's one of the things that is pretty universal. If you have to transfer it completely, it has to be done in writing. That's Trinidad and Tobago is the same in the US. And if there's ever a dispute, having something in writing will come in handy because that's what you're going to have to rely on as evidence. Okay. So we're going to move on now to have my film, I have my script. And I know that the script has copyright, but is there anything else that has copyright attached to my film? Because the script has copyright and the film itself has copyright. Anything else? Yes, okay. The screenplay will have copyright. The film itself will have copyright. This is after you've shot it. Original characters will have copyright. But not concepts, okay? General concepts are not protectable. So that's why you can have a class struggle romance in Romeo and Juliet. You can, in West Side Story, in Basudi, in 10 million films, because the concept is not protectable. It's only how you express it. It's the original expression of the idea. Which is going to bring us to the concept of original characters. Because remember, I put in that word original when we were dealing with the definition. We're going to play a little clip, and then we're going to talk about it. This is a Honda case. We see 007 on my slide, and they are connected. So let's take a look at the video.
That wasn't so bad.
Well, I wouldn't congratulate yourself quite yet.
I see. Uh-oh.
What is it?
Nothing. Guess who?
I'm sorry.
It's fine. Excuse me.
Don't you just love the wind through your hair?
What I have left.
So this is the Honda case. As you can see from the ad, Honda had this ad campaign for the Del Sol vehicle using a very 007 type character. And MGM, the studio, sued Honda because they did not give permission for them to use a character like Bond. They were suggesting that this is a Bond-esque character. And you're going to ask, well, so people can't use characters or in the advertising. Now, the thing is, if your character is sufficiently original, how did we know by looking at that ad that they were trying to make it seem like Bond? It has to be because there are things about Bond that we know. He wears suits. He's a ladies' man. He fights villains, and they usually very much like this one where there was a sort of technology-based villain, and he has high-speed chases. All of these things, he drinks martinis. All of these things are things that make the character distinct. He's not just any random guy. He's British. All of these things make the character distinct. The more characteristics you add, the more copyrightable a character is and protectable a character is. If you just have a guy in his 40s, that could be anybody. You can't get copyright protection for that. But when you see somebody, and that's why you can have different actors play a character, but you still know who the character is. It's the same thing for Batman. So if the character is sufficiently distinct, the character can be protected. And they won this, of course, Honda tried to say, it was just a parody. They didn't succeed, and they had to pay They had to pay MGM, okay? So that's worth remembering. If you come up with some sort of amazingly original character, let's say you do a local superhero film. I did not see Batshak Man, but perhaps if he has enough unique characteristics, the concept, that character might be protectable. So that's something to remember. The part of your film that will not be protectable will be known as scène affaire, which is like anything that's typical. So if you have a romance and then two people kiss in the rain, that sort of concept and scene is not protectable because almost every romance is going to have that. You can't have a monopoly on that. But if you create this very original character, you get the right to exploit it. So we're going to move on now to ideas. Remember I said, it seems unfair that my idea could just be used and it's not protected by copyright. Well, let's talk a little bit about how you might be able to protect it. Maybe not copyright because you haven't reduced it into some sort of tangible form, but there's a case called Disney against Wilder. It's an old case, but this case set the precedent. This is why studios, talent agencies don't take unsolicited material and scripts from people because they just don't want to get sued. What happened was a guy called the studio and said, I have this amazing idea for a film. The secretary answered and he told her, and she took notes over the phone and said she would give it to her boss, which she later did. Idea for a movie. And then they made the movie. The boss, they checked the notes and was like, yeah, I like this, made the movie. The guy didn't get any compensation, so he sued. And the issue was, well, it was an idea. Yes, but the secretary wrote it down. So it was fixed at that point. And he only gave the idea to them on the express assumption that if they use it, it's a movie studio, that he would get compensation. So this is important for people who do pitches, which you always have to do if you're a filmmaker, an independent filmmaker. You need to remember that other people are not entitled to exploit you in that way. Okay, so make sure you have a friend with you when you're doing your pitches. That friend will serve as a witness if ever you need one. And before you do your pitch, make sure that you say, okay, and of course, I'm about to disclose my story for my film. And this is on the assumption that should you decide to use it commercially or in any way, that I will be remunerated fairly. And they say yes, of course. At that point, it becomes contract law. So there's a distinction. There's copyright law, which ideas are not covered by, and then there's contract law. Here, you just said, I will give you this if you give me that. And they say yes, and then you give them the idea. So you switch into a different category of law under which you should get some protection. So this is just helpful to note with the distinction between copyright and protecting yourself as a filmmaker. This came up with the case of Bear and Chase. You have my Sopranos poster up there. So this happened with Sopranos, the guy who believed that he came up with the idea because he liked gangster films and he was kind of fascinated with them after watching one of those gangster movies. He spoke to Mr. Bear, who ended up being the executive producer of The Sopranos, and told him, I think it'll be really amazing and to do this movie. Now, Bear himself was also very into the mob and he was very fascinated by it. So when he met this guy and spoke to him, the gentleman made a few introductions in New Jersey to people so that he could interview them and get a little idea of how, I guess, the mob works. And then the guy sued. He was like, oh, it was my idea. The series was my idea. And he lost, of course. He lost that case because the executive producer was also the person who had a similar idea, and there was no discussion about making introductions, entitling this other person to remuneration if the executive producer at some point in time did go on to make a series, which he did. So that's your note on idea theft. We will move on now to copyright impacting your budget. So remember that copyright is an exclusive right, and you can prevent people from doing things. And you need to give people permission if they need to use your work. It's just like with Green Days by the River, using that as an example, where, again, we move on to the next slide. It's a book, and the book has copyright, and then you want to adapt it into a film. So Michael Anthony had to give permission as a copyright owner for Mulidor to then make a film, and that's the adaptation right. He had to get a license to do that. Filmmakers need licenses if they need to make a film based on an underlying work. Maybe there was a story that you read. The movie Hustlers was based on an article, so they actually had to get permission from the author to use that to adapt it into a film. So this is something that happens all the time. It gets a little bit more fuzzy when you go into life rights because, well, we don't have life rights in Trinidad per se. But then there's news, things that are in the public domain as news you're entitled to. Nobody has a monopoly on news. So you can make a film about things that are in the public domain. You need to get releases from performers because they have a copyright in their performance. This is a recent development in copyright law in Trinidad and Tobago. So once you have a release that covers this, you should be fine. But you need to make sure all of your performance releases for your actors and your extras are updated to include performances. And you need to get permission for music in your film, very, very important, and to display copyrighted objects in your film. So you know that you need to get permission for music. I know that's going to be dealt with separately. But what about objects that are visible in your film? Like paintings in the background of a scene, or music playing on the radio, or a character watching TV and they're watching a show on TV. The show that they're watching has copyright. You need to get permission from the person who owns the copyright in that show to then do the scene of somebody watching a show, or pictures, framed photos in your scene. Photos have copyright. You need to get permission from the person who owns the copyright in the photo for you to have it in your scene to then put it into your movie. So all of these things have to be budgeted for. Otherwise, you risk litigation. So we'll move on because you're going to say, well, it was just for a few seconds. We'll go to the next slide. Well, there have been many cases about using copyrighted material in film. This is one of the more popular ones, the Mike Tyson tattoo issue with Hangover. They did not get permission from the tattoo artist, who believed and he claimed that it was an original tattoo that he did, and he registered it with the U.S. Copyright Office. And when the movie was about to come out, he sued Warner Brothers, and that could have prevented them from releasing. This was a huge movie. They would from making the money that they would have made. This was a very popular movie. It was already a sequel, so it had goodwill. People were anticipating it. If they were to go to court and lose, they wouldn't have been able to put the movie out, and they would have lost much more than I'm sure they paid him. It was settled for undisclosed amount. If you don't get permission, you risk getting sued. You risk being able to get money back, just like they would have if they didn't pay. And it's going to be embarrassing as well. Note on this point, this is based on a Maori tattoo, which is an indigenous, from like New Zealand. And he is American, so he's not Maori. So he's claiming that if it had gone to trial, this would have been interesting to see that point, because he's claiming it's an original creation but it's traditional cultural expression of the Maori people. So I don't really know if he could claim a monopoly on that, but it was never litigated fully. It was settled. But this is what can happen. On the next slide, you'll see the Ringgold and BET case, which is the church story picnic quilt. You see a picture of it right there. It was used in the background of a scene, if you could remember the show Rock that used to show on BET, Charles S. Dutton and early Jamie Foxx. And it was in the background of a scene for between 1.8 seconds and 4 seconds. Each time they cut back and forth for a total of 26 seconds. For 26 seconds. And the court agreed, 26 seconds out of a half an hour comedy, that it was enough to infringe in the background of the scene because it may have impacted on because it didn't get permission from the person to use the work, and it may have impacted on the artist's ability to make money from the work, right? They claimed fair use. Now you're going to ask, well, what is fair use? People always say, if I just had it for a little while, well, fair use is a defense to infringement. So the infringement has already occurred by the time you're trying to claim, don't sue me, it was fair use. Or fair dealing, as we have in Trinidad and Tobago. But this is just to give you an idea of taking chances. They said 26 seconds not going to be a big deal, but then BET had to pay money in the end. Okay, so it's really better to use your own original art in the background of your films and your own photos. Be very careful when you're framing your shots so that you can avoid unintentionally infringing on somebody's copyright. Now, you can use things that are in the public domain, and public domain doesn't mean freely available on the internet. In terms of copyright, it means no longer protected by copyright, okay? It means it's outside. So something that Shakespeare would have done is outside of copyright because it was done however many hundreds of years ago. Which is actually a good idea for filmmakers. You can use material that's in the public domain like that to then make your own, to base material to make your own original screenplay based on that. You can rework it. You don't need to get permission. But then you'll say, well, if I don't get permission and somebody comes to me and claims that there's been infringement, do I have any way of shielding myself? Well, you can maybe say, if you're in the States, you can say it was fair use, which considers 4 factors when the court decides whether the use was fair or not. In Trinidad and Tobago, however, we don't have fair use, we have fair dealing. Fair dealing is different because any country that has fair dealing in their law means that whatever exclusions they've put into their law are the only categories you can use somebody else's property, somebody else's intellectual property for. Now, I know I'm running out of time. I want to check if is it okay for me to go over by a few minutes? I'm not hearing anything.
Yes. Yeah.
Okay. Yeah. Okay. Great. Right. So I'm just gonna go over here. So the distinction between fair use and fair dealing. Any country that has fair dealing in their law, copyright law, means that whatever they've written into their copyright law, those are the categories that you can use somebody else's work for. Only what they've put in. So in Trinidad and Tobago, we have education for fair dealing, for the news, for libraries and archival purposes. So you can use somebody else's work for these purposes without asking for permission. But it's just kind of qualified to the extent that's necessary. That's what's written in the law, right? Fair use is different, where they have 4 factors that they consider. The court considers 4 factors. The nature of the work, and the type of use, the nature and the characteristics of the use. So if you use it commercially or non-commercially, the type of copyright work, so whether it was music or film or book or, right? How much was used in relation to the whole of the work? Now, in this case, they didn't put a piece of the quilt, the entire thing was displayed. So that's another reason that may not have gone in their favor was, and those are things that also are important for music. How much of it was used versus the whole? And the question of, will it impact on the commercial viability of the original work? Because remember, copyright is all about making money. And if I can't make money from my work because of how you use it, that's a problem. So that's how they consider fair use in those territories. It's very fact specific. It will always come down to an assessment of the facts. If you decide, well, I'm gonna use this as my defense. You've already been sued by this point, which is why it's important to get advice before you take the risk. You might get legal advice and they say, well, I think it would, the attorney may say, I think it would be, you have a good fair use defense here, go ahead. And if you get sued, that's what you're gonna see. But you need to know the difference between the two. Here in Trinidad and Tobago, remember, it's not fair use, it's fair dealing, which is educational use, libraries and archives, reporting of news. Those are very, very limited. That's very limited in scope, and it's also to the extent necessary. So educational use doesn't mean you can go and photocopy a whole book, but you could photocopy a few pages from a chapter. All right. There are other instances that you might have. You may have other defenses. Parody as a defense. If something isn't, if somebody is claiming that you're using, as I said, using the Mike Tyson example, if that had gone to court and I was in Warner Brothers' corner, I would say that he is claiming copyright for something he doesn't own, because that's a Maori tattoo. It's a Maori inspired tattoo, and no one person should be able to own an entire indigenous group's type, method, or form of cultural expression. If they chose to do the same design, what would you do? Tell them that they can't do it? But it never got to that. So in terms of being sued, you can always say maybe what you are being sued for is not original. You can't have copyright protection on something that's not original. You might think you have copyright in something, and then when it gets to the point of suing for somebody else using it without your permission, that other person, who might be you as the filmmaker, in terms of thinking about what you could say to defend yourself, these are some of the things that you might be trying to pull out. Okay. All right, we're almost to the end. Let me just go on. And how do I avoid infringement? Very important. Put things in writing. Assignments, as I mentioned, when you are fully giving away a copyright, has to be in writing for it to be valid. But even if you're just giving somebody permission to use something, do it in writing. A simple email doesn't have to be complex. A simple email can work. Avoid copying substantially. That one is easy. You can get moral rights waived in writing. Compose your shots to avoid, which we just spoke about, using other people's or any other copyrighted material in the background, or audible music that you didn't get permission for. You can get your own dedicated composer for your film so that you don't have to use, and let them make original music for you so that you don't have to get permission from other people. But if you do that, make sure you're going to write in writing an agreement with that person who you bring on board, so that there is that documentation showing that this work, music that you're making for me, who's going to own it after? Are they going to own it and they're just giving you permission to put it in your film? Or you're bringing them on, you're paying them money, and you're going to own it. Don't assume that because you pay somebody to do something, that you pay someone to do something, that you own it. Commissioning work does not mean that you own it. It just means you paid someone to do it. So make sure that if you commission work, that you get that assignment of the copyright to you or your production company in writing. Okay? And what next? How do I enforce my copyright? Very important. Make sure you put your copyright notice, which is the year, your name, all rights reserved, on your copyrighted material. You will see it on every film. You'll see it on scripts. Put it on everything. Use watermarks. Okay? Use digital thumbprints if you can do that. Use anything to indicate your ownership. That will help. Now, if you do see a material on social media platforms that you didn't, let's say YouTube, in the US, because it's a US company, they have the Digital Millennium Copyright Act, where you, the copyright owner, can notify a website or a social media platform and tell them to flag something and take it down. So you should use the notice and take down provisions if you're a copyright owner and you've seen your material somewhere else that you didn't give permission for, particularly websites. This is especially useful for the US and social media platforms. It might be a little bit more tricky with social media platforms, but definitely for YouTube, because social media platforms are governed by whatever contract you have as a user with the platform. Cease and desist letters almost always work. So go to a lawyer and tell them, this person is using my copyrighted material, or whatever it is. Maybe they haven't yet, but they're threatening to, and you see an ad, or you heard that they have in production meetings or whatever it is. Cease and desist letter, those usually work. Where somebody gets sued is a matter of jurisdiction, which we're not going to go into, because you can be from Trinidad and Tobago and infringement occurs in the US and you want to bring a suit there. That's outside the scope of this presentation, but you will need to get advice on that, okay? And let's see, what do I have here? Right, you can always sue someone. If worse comes to worse and you send a cease and desist letter and they don't agree, you can sue them as the copyright owner and feel confident that you will be able to get your money back. So in terms of resources and who to go to, I always suggest Trinidad and Tobago Intellectual Property Office, which is the next slide. Intellectual property attorneys, because not all attorneys, as a matter of fact, very few attorneys understand intellectual property. It's not something that you just learn in law school. And even if you get a broad understanding of it, it's very distinct. So you should go to an intellectual property attorney to get advice on intellectual property matters. Trinidad and Tobago Intellectual Property Office, which is part of the Ministry of Attorney General Legal Affairs, they have a list of intellectual property attorneys. They can point you in the right direction. Performing rights organizations, film associations of professionals, for example, in the US, unions, which they have in the US, these are all great resources. Film commissions as well, great resources when you need help, if you have a question. Maybe you don't feel like you need to go to an attorney yet, but you want to bounce something off of somebody. These are the people that you need to call, email, talk to. And I think that is about it for now. It's to cover our general discussion on copyright for today. So that brings me to the end of my presentation. Thank you so much for allowing me to go 10 minutes over.
Sure. No problem. Thank you, Cindy. I have a couple questions for you, if we could try to address them really quickly.
Sure.
So let's say you come up with an idea for a story, you write a script, TV series, whether it's a series or a feature, whatever, and you want to collaborate with someone and you bring somebody on to write with you. And you say, okay, this is my idea, so it's going to remain my property, but I'll pay you this percentage. Or let's say you come up with an agreement, but then it goes sour and you split. And after they've given inputs, how does that work? Let's say there's muddy waters and some of the input is still there, but the story has changed since they've left. What happens there?
Okay, let me go back a little bit. Did you write the majority of the script?
Let's say, yeah.
that the person, I guess the correct answer is it depends, right? And it will always depend. For example, if you've written the majority of the script and you brought this person on to help, and there was a written agreement that they would help in exchange for remuneration, that doesn't mean that they're entitled to ownership.
Right.
Just means that they're entitled to remuneration. So if this makes money, you will get
so and so percentage of this pay.
5% of of adjusted gross, right? Or whatever it is. But you still own it. It's just that they agreed to come on board and give their contribution for deferred deferred compensation.
And then the partnership breaks up after they give input. How does that work?
Right. Now, it depends on if your agreement dealt with that. It also would depend on if the partnership has broken up at that point, but they've already given their contribution. Since the agreement was to give the contribution for the remuneration, they may still be entitled to the remuneration, because if you're still using the material, but you just no longer have a relationship with them. Because if your brother wants to do something and they did it, at that point, the relationship doesn't need to continue.
Right, but what I'm saying is, what if the relationship discontinues and some of the information remains in the story because it was integrated into the story, but the story has changed since the split?
Well,
how is that?
It also depends on that. How much of their contribution remains in terms of what was used, because scripts go through different iterations. So, and that happens all the time, which is why it's important. That happens all the time in the US, because writing is rewriting. They always say writing is rewriting, right? So it's important. That's another reason why you need to have written agreements. It will discuss things like what happens in the event, how do we separate, what are you entitled to. But in the end, if this ever has to get litigated, it would depend on how much of what they've given is still in what is being used. And then when it makes money, that they will have to be they will then be entitled to whatever percentage they were supposed to get.
Okay.
But if what they contributed was not used, because maybe that was the foundation of the agreement, that I'm supposed to give this, and if it's used in the final script, then, because many writing agreements say that.
Yeah.
You may get rid of a writer, and it happens in the States.
Like if you create a character, if it's used, then you get paid, basically.
Yes.
So that brings me to my other question. Sorry, we have a lag. Sorry. Go ahead.
Right. Yeah, that happens a lot in writer agreements in the US, because they may not be satisfied and then they would want to get rid of somebody. But it's usually covered in the agreement, which is why those agreements are long.
Right. Okay, and that was leading me to another question that I had. So are characters in a script automatically copyrighted when you copyright a script? Or do you have to, is that like a separate thing?
Okay. And I probably didn't say this during the presentation because I say it so many times, but remember that copyright is automatic, right? It's only the registration for the purposes of the domestic law in the US for suing people. But as soon as you create it, you get copyright. Only the characters that are sufficiently distinct will attract copyright.
Right.
So
like a Batman, he will automatically be copyrighted.
So like 007 is a good example. Like Batman is, and then there's Superman. There was even a case with Superman where there was another competing studio that did almost like an ordinary guy. He was like a Superman, but he was like a teacher, and he was getting divorced, and he was like an ordinary guy. This was in the 80s, I think. And they sued. And Warner Brothers sued and they lost. They lost that case. This is the Honda case where MGM won, because they said, yeah, but your character is like this guy who's like Man of Steel, and he does all these things, and he's, their character is the opposite. So they're not infringing on your copyright at all. Whereas with the 007, you clearly saw that they were trying to recreate a version of that character. But we know he drives Aston Martins. He doesn't drive a Honda, right? So they were saying, aside from that, I don't remember if they also sued under trademark, which they probably could have for trademark dilution. But in terms of the character, the 007 character, yeah, they were clearly they were using the character.
Okay, and like when you're making a deal with a foreign country, let's say, like you were talking about foreign, do you hire a local lawyer? Let's say you're Trinidadian. Do you hire a local lawyer or do you hire a lawyer in that country? Like if it's the US or Canada or the UK? Or do you hire both?
It depends on what kind of agreement you're doing, right?
Okay.
So if it really depends on what kind of agreement you're doing. There are many agreements that can be reviewed by an attorney here. If, however, it's an agreement for work that primarily has to happen there, because as I said, the issue of jurisdiction takes different things into consideration, including where the work occurs, the impact, who is even in the US, because it's a federal system, they have different states, and even within there, you would have attorneys who are called to the bar by state. You're only licensed to practice in your state because the law is different in another state, and it's the same thing. Like when you have to decide, if it depends on things like where the work will be done, what type of agreement it is, what is it for. Many times it will be something that can be reviewed by an attorney here, and they will be able to tell you need to get advice from somebody else on if they believe that it's the kind of agreement that needs advice from somebody who is within the territory.
So it's a good idea to start with a local lawyer when it comes to international deals.
Yes.
Okay.
And
Great.
I think in most instances, I shouldn't say that, but I feel like a lot of the time you can get past the hurdle here, and they will be able to tell you. They should tell you if you need to get something, because it would be wrong for them to advise. Because I can't advise on U.S. law. I can give you information, but I can't advise on it because I'm not called in any of these states.
Right.
Yet.
Another question, something you were talking about a little bit earlier. You were saying, like, say you're a director and you want to make your own film and you wrote your script. You were saying to assign your script to your company that is going to produce it. Why is that so necessary if it is your script anywhere in your company?
Okay. This is a very good question. So, Tanil, do you have a production company?
Yeah, I do.
What is your production company called?
10 Productions.
And is it 10 Productions Limited?
Limited, yeah.
Right. So, you, Tanil, are a natural person, and it's almost as though you are almost like an employee of the company, right? Or maybe you're an independent contractor of the company, because the whole point of creating a company is to have a shield for you in the event that somebody has to get sued.
Right.
That the company gets sued and not you, and they don't come and take your car,
your house, and everything.
Right?
Yeah,
exactly. And then right. So by that token, if you are one person and the company is one legal person, and if I have to sue the company, then where's the connection between you, the human person, and the company, the legal person? There has to be a line between the two to show that I wrote the script and this entity called 10 Productions Limited owns it.
Right.
So all you need is as I said, simple one page to assign the copyright from the person who owns the company or whoever created it, because let's assume you got a friend to do it for your company. It will be the same thing, where you need to make sure that they assign it to the company so that it being your company, you can then exploit it.
Okay. Yep, makes sense. All right. Okay, we're so over time, but it was so much useful information, Cindy. It really was. I'm sure we could go on for another 20 minutes.
Yeah, I could do a whole hour on fair use, unfair dealing alone. So I know it's always dense copyright. But thank you for indulging me with the extra 10 minutes.
No, it was very necessary. This is an important topic for locals to understand, local filmmakers, to understand. So I just want to say thank you again to the viewers for also attending the event, brought to you with the support of Republic Bank Limited. On behalf of the TTFF, we hope that you gain, and I think you would have some insight into this topic, and hope to see you again at other events throughout the rest of the festival. If you have any feedback, you feel free to email me, admin@filmco.org. And if you post about us on social media, please tag us. Enjoy the rest of the festival, everybody. Bye.